And today I want you to, and you said, well, it's the governor's right. Even how many times he can sit on it, 3 months, maybe after that also. But today the Honorable Supreme Court has said very well, and I think they have spoken out for the will of the people, so that the common man does not suffer, that you do not have the right all the time to play ping pong with what the needs of the government are. Satish Kumar, over to your opening comments, sir.
Good evening, Sudha. However, I accept that it is an historical judgment, and I very well remember the same issue we have discussed on many occasions previously.
Yes, Satish.
And we were very specifically saying that yes, a timeline is required, especially by amending the article, or judicial clarity is required on this aspect. That we discussed, especially in our channel, on many occasions. Now, the historical judgment has given a clarity, at least on the timeline, that is whether it's 1 month or 3 months, something like that has been, a clarity has been given in this aspect. No doubt, any amendment, because in a constitution which comes out, is definitely is an historical movement only for a country like India, which is celebrating its democracy on each and every day. So on this point, I am not denying that it is an historical judgment, because when the constitution was brought into action in 1950, in 1951 itself there was an amendment came. So that is the democratic system of our country. That's what we are celebrating, our country as a democratic country. So taking this as a pride or maybe a victory for one state, I feel that there is no big victory for the state. The state has brought wanted a clarity on Article 200. That clarity is given, and I always I feel that because of the maybe the controversy or the contradiction, or maybe a lack of clarity on the Article 200 by the governor and also by the state government, has brought to an end by this judgment.
Absolutely. So and also, Satish, let me read out, you know what R.N. Ravi has said on different occasions. When a governor withholds assent to a bill, it means the bill is dead. He buried it already. Without these bills, of course, have to do with the Tamil Nadu University's law, Fisheries University, Vet and Animal Sciences, Siddha Medical University bill. I mean, to say the bill is dead, don't you? You can say the bill is delayed. The Honorable Governor.
I differ to some extent on your point. What our Honorable Governor said about whether it's a dead or buried is a different issue. Because as of today, when the amendment, the clarity on the amendment of Article 200 has come, till that moment, what governor said, we cannot deny 100% the statement of the governor.
Yeah, but there is another, Satish, much like you, there is another very prominent lawyer from our own Tamil Nadu. His name happens to be Palniyappan Chidambaram. You know what he said? Actually, when a governor withholds assent for no valid reason, it means parliamentary democracy is dead. Selam Dharnidharan, let me get you into this, a historical, kind of victory for you, in the sense, the will of the people. I am not looking at it from any other prism. I don't know how many children must be waiting, what that bill could have done for scores of children there. Don't you think, Dharnidharan, I feel it and I am going to stick my neck out. This was totally political, He said, given to me, I will never clear the NEET bill. I mean, it was totally a political slugfest which was being played out. I don't mean all the other governors, but this particular governor. Your point, Dharnidharan.
See, my point is very simple. I think people don't understand the basic fabric of democracy, right? Fifth standard civic, it says India is indirect democracy, which means that we elect representatives, people elect representatives, because you can't have 8.4 crore people deciding in one place. So they elect their representatives, that is 234 legislators, and these legislators will represent the voice of their constituents, which is rather representing 8.4 crore people. So when Tamil Nadu House passes a bill, it clearly implies the voice of the 8.4 crore Tamil people. It's not that DMK, ADMK or PMK or anything, which is why for NEET, most parties in Tamil Nadu came forward and supported anti-NEET bill. It's because as politicians, we have to listen to the voice of the people, right? What is the job of a legislator? To legislate representing the voice of the people. But how can a governor go and sit on it inordinately? In fact, I haven't said the judgment yet because the judgment has not come out. But I did read the submission. Even in the submission, the Tamil Nadu government has made it clear, and governor is an appointee when he can inordinately sit on a bill, or maybe even by which the bill becomes annulled, which are dead, which means that it's an autocracy. Because in democracy, the government forms the bill, representing the voice of the people. In case if the government fails to listen to the people's voice, not listening to the voice, the people, like the people of Tamil Nadu, throw that government out. That is the beauty of one democracy. In spite of that, how can someone who's an appointee decide on something? Isn't that autocracy? This was made in the submission. So which I think is we stand vindicated. And once again, like how Tamil Nadu made sure that Hindi is not made the national language by protest in 1965.